Hello, my true crime lovelies. How are you? I hope you are well. I hope you are as lovely in life as you are in my mind. Oh, Wendy does not want to testify for the defense. And I don't know how Donna feels about it, but she can't be mad. I mean, she didn't want to testify for the defense or the state in Charlie's trial. Of course, the state wasn't offering her immunity, but they didn't even want to be deposed. Like they being Javi and Donna haven't been talked to by law enforcement because if you remember, after Dan's memorial, Dan Markel, who is the decedent in this case, who is the victim, and I want to send my condolences out to his family and loved ones and everyone impacted by his loss. After his memorial, the Tallahassee PD wanted to talk to Donna and Javi, and they said, yeah, we'll swing by after. And they got on the highway with their daughter, Wendi. And then I think someone also called Wendi. I can't remember, maybe Sanford, maybe Newland, somebody from Tallahassee PD to ask questions. Excuse me, to ask follow up questions. And she was like, "What's that? I can't hear you. I'm going through a tunnel." Click. And then her attorney called them. So hopefully Donna's not mad, but who knows? Who knows what Donna is feeling? But we're gonna get into Wendy's statements. And I have thoughts. I have my 2 cents, and I definitely want to invite you to share yours in the comments with me. But first, I'm going to thank the members. I want to thank you all for being here. Whether or not you're a member, if you like the video, please give it a thumbs up. If you like what you see, consider subscribing. We're a good bunch over here. All right, I'll see you on the other side. All right, here we go. Non-party Wendi J for Jill, Adelson's motion for permission to place a statement on the record and to quash defense subpoena. Intro, non-party Wendi Jill Adelson, Wendi with an I, is the daughter of defendant Donna Adelson. Shout out to Susan Opper, and is expected to be one of the first witnesses called by the state in Donna Adelson's trial. Both the state and the defendant issued trial subpoenas to Wendi Adelson. By law, the state subpoena confers immunity on Wendi Adelson, but the defendant's subpoena does not. Now, by law, does that mean everybody gets immunity, or by law, the state is the only party that can confer, which is how I'm interpreting it, but it's written a little bit ambiguous as a non lawyer reading this. Accordingly, Wendi Adelson respectfully moves for permission to place a statement on the record regarding the state of Florida's trial subpoena, Exhibit 1, and to quash the trial subpoena issued by defendant Donna Sue Adelson, Exhibit 2. In support of this motion, Wendi Adelson states as follows. Well, come on, girl, what you gonna state? Donna Adelson is charged by indictment with first-degree murder, alleging she participated in a conspiracy to unalive Dan Markel, Wendi Adelson's ex-husband, on July 18th, 2014. Other alleged members of the conspiracy were charged and convicted, including Catherine McBanawa. In the McBanawa trial, both the state and the defendant subpoenaed Wendi Adelson to testify. And they are citing, it's the 2016 case. I don't know. So Katie had 2 trials, you guys know. One with Sigfredo, which there was a hung jury. One person was worried about the children of Sigfredo and Catherine, and so they did not want to convict her. And then in the second trial, she was convicted. In response, she was in jail, though, from the entire time from when she was arrested in 2016, and I don't think she was it was 2022 that she was actually convicted, so a long time. In response, Wendi Adelson filed a motion like the instant motion to place a statement on the record and to quash the defense subpoena on May 13th, 2022. Okay, so that's the second trial. Thus, the two trial subpoenas by each party in this case present the same issue the court dealt with in a previous trial. The state subpoena affords Wendi Adelson use and derivative use immunity for her testimony in an instance where she would otherwise invoke her Fifth Amendment rights, which is the right to not incriminate yourself. Why would you be incriminating yourself, Wendi? Do tell. While the defense subpoena provides no such protections, Wendi is not going to have it without protection. In the Magbanua trial, the court quashed the defense subpoena and granted Wendi Adelson's attorney an opportunity to place a statement on the record. See Exhibit 3, 5/19/22, transcript of ruling and statement on the record in Magbanua. We request the court grant the same relief in this case. So it's the court, but it's a different judge. There's actually 3 different judges. We'll see it in the exhibit, but obviously Judge Everett was not presiding over the case for Katie the first time or Katie the second time. So Wendi Adelson, memorandum of law, the court should allow Wendi Adelson's attorney to place a statement on the record regarding the state subpoena. Wendi Adelson will testify pursuant to the state subpoena, but without such a subpoena, she would invoke her rights under the Fifth Amendment to the United States Constitution. So he's like, get it straight. The only reason she's agreeing to testify for the state is because they are giving her this immunity. Otherwise, she would plead the Fifth, right? Which there's a deposition by Katie's attorneys, Tara Kawas, where Wendi, I think if you go to AA Legal Focus, Judy has the reading of that deposition on her channel, but she just says she pleads or I invoke or whatever she's saying, but like she just repeats it over and over. So Wendi Adelson's testimony is entitled to use and derivative use immunity. She intends to invoke her Fifth Amendment. So it extends to any testimony given during Donna Adelson's cross-examination of Wendi Adelson. So they're saying the defense has an opportunity to question Wendi, but they need to do it on cross because then she's protected. And in general, cross is limited to what the state has discussed, right, during their direct questioning. Given the state's theory of the case, there's no question that Wendi Adelson has a real and substantial interest in asserting her rights against compelled testimony. Then they cite a bunch of cases. Then we have, in these proceedings, Wendi Adelson has made a complete invocation of her rights under the U.S. and Florida constitutions. To ensure full protection of Wendi Adelson's rights, she respectfully requests the opportunity to state on the record her entitlement to these important constitutional and statutory rights. Oh, we know about Wendi's entitlement, sir. The court should quash the defense subpoena. Donna will have a full and fair opportunity to cross-examine Wendi, and despite knowing that she would otherwise assert her Fifth Amendment rights, Donna Adelson's counsel issued the defense subpoena. So they're like, y'all already knew, why are you playing? Unlike the state subpoena, defense subpoena confers no such immunity. And then they go on to cite some different things. If called as a defense witness, Wendi would invoke her Fifth Amendment rights to every relevant defense question. Therefore, any testimony Wendi Adelson provides beyond the matters covered under the state subpoena would result in a potential waiver of her Fifth Amendment rights. And she ain't waiving her rights, y'all, which she does not intend to do. Carter v. State, Florida 3rd District. Court of Appeals 86. Florida law is equally clear that it would be improper for a party to call a witness for that witness to invoke her rights before the jury. Ashley v. State. I mean, and ultimately, I think it would make Mama Donna look even more guilty, right? You called her up here, like finger pointing guilty, like, look at her, look at her. That's suspicious. I don't know. If you were a jury member, wouldn't you think it was odd that your daughter, when testifying on your behalf, refused to answer? I don't know. I wouldn't do it. Anyway, but also I don't do crimes. Calling a witness to invoke Fifth Amendment protections in front of the jury creates a dramatic moment causing irreparable damage and injury in the eyes of the jury. So I think her attorney means irreparable damage to Wendi, but I think it's also irreparable damage to Donna. Maybe that's also what he means, but it seems like Donna's counsel should be more concerned about that than Wendi's counsel, right? Especially after the state would have examined her and the defense done cross. And then when the defense calls her, she's pleading the fifth. Like it's giving no, don't do it. Thus, there is no proper purpose for the defense subpoena, and it should therefore be quashed to ensure the integrity of the trial process and to protect Wendi Adelson from unnecessary harassment and abuse. Wendi will not be abused by Josh and, oh my God, Jackie. No abuse. Under these circumstances, defense subpoena should therefore be quashed. Conclusion, and then they go through all this. I want to get into some of these exhibits. So they've added the subpoenas, witness subpoena, one for the state, and told her when she needs to appear, right? So 8:15 on 8/21 through 9:05. So I think 8/21 is like the first day of trial, like of testimony, because the jury selection starts on the 19th, and I think they said like 2.5 days. So 21st is up. Through 9/5. So subpoena is binding day to day and week to week until case is closed. What a disruption of your life to have to sit in a state, because she's not even in Florida anymore, and wait. I mean, I don't feel sorry for her because she's guilty, but allegedly, but I wouldn't want to do it. And then here is the subpoena from Joshi and Jackie. So we have those. Exhibit 4. Some of these were repetitive, so I took them out. So I wouldn't scroll too much because I know how that's unnerving for some of you guys, and I want you to enjoy the video. So this is the Honorable Robert Wheeler. This was in 2022, where McBanawa had filed to have Wendi. I'm going to skip this part because this is just Kawhi complaining about not having her notes to cross-examine Jeff Lacasse. Okay, so first thing that I want to address, and this is the judge speaking, is in regards to Wendi Adelson and a non-party motion that I received. And so is Mr. Lauro present? Mr. Lauro, yes, Your Honor. Good morning. The court. Okay, Mr. Lauro, good morning. Let's see. We don't have the podium in a good place at this point, but if you could just step right up to the podium. Good morning. And we know that Judge Everett clarifies that it is not a podium, it is a lectern, but to each his own. Mr. Lauro, yes, Your Honor, John Lauro, and with me is Ms. Adelson. Your Honor, as you know, Ms. Adelson has been subpoenaed by the state as well as the defense. She, without a state subpoena, would unequivocally invoke her Fifth Amendment rights. We want to make that clear for the record. In light of Your Honor's prior ruling and direction, we wanted to put that on the record. However, with respect to the state subpoena, it automatically confers use and derivative use immunity on her pursuant to Florida Statute 91404. And also, I want to clarify, it's just while she's testifying, because I've been in some chats of other channels. I think I saw this in STS, but don't quote me, where someone was like, why would anyone give her immunity, like blanket immunity. She doesn't have blanket immunity. It's while she's testifying, what she says in and of itself cannot be used to prosecute her. But if there is separate evidence of it, like she doesn't get a get out of jail free card, right? It can still be used as long as the state can substantiate where they got the information from. So she can't just get on the stand and say, yeah, yes, I was involved in the murder, and then that can never be used against her. If there's other evidence that supports that she was involved in it, they will charge her. I know there's a lot of debate if she will be charged or not. I hope that she will. I do worry about her children. I know they're teenagers now. There's a lot going on. I don't know what story is being told to them. Like, I'm sure they're asking, where's Uncle Charlie and Grandma Grandma Adelson. So, yeah, my concern is for them. Maybe the state has like this long game that once the boys are 18 or the old, I don't know, but I do worry about them. Okay, so in light of that, we would ask respectfully that the court quash the defendant's subpoena. So it's very similar language of what he wrote in his motion to Everett as what he's stating on the record to this judge. So the judge says, let me ask you this, Mr. Lauro. Any questions that are given to Ms. Adelson during, if she was called with the defense case, is she going to assert her Fifth Amendment rights to any question that's asked at that time? Mr. Lauro, yes, Your Honor. I'm assuming any question would have to be relevant and germane to the matters in this case. And as a result, she would invoke as to those questions, the court. All right. And so I'm just going to assert my previous ruling that I've made, and I did restate it on the record yesterday, is that she'll be required to testify under the state subpoena. The cross-examination will be limited to whatever the state brings forth on direct. So that's what the cross-examination scope will be limited to, which in general, in most cases, that happens unless they're trying to impeach the witness. There's exceptions, but in general, it's your cross-examination scope is what was brought forth on the direct of the state or the Commonwealth, the prosecutor, depending on where you are. There's no piggybacking or bringing in any other information just because she's under the state subpoena. That's not going to be permissible. And then she's not going to be permitted to be called as a witness. Now that we know that she's just going to assert her Fifth Amendment right, she won't be called as a witness in the defense case at this time. Mr. Lauro, yes, Your Honor, that's exactly our understanding of the law. And then they say, all right, okay. They call this first witness. She wants to follow up on a different issue. You can slow that down if you want to see it. And then this is from the very first case where it was Sigfredo Garcia and Katie together. And there we had the Honorable James C. Hankinson. And we don't have the first page, but it starts with no Adelsons. And Georgia says, oh, I'm sorry, yes. So we need to have some discussion about immunity. Is she here? Let's have the witness take the stand. Mr. DeCoste, Your Honor, should I call off my reporter? I'd like to mitigate costs, and I don't think that we'll be. Wait a little while, the court says, DeCoste. I don't think we'll be able to complete the depositions today then because we're going to lose the reporter at about 6, the court. Come on up, ma'am. Place her under oath, please. Whereupon... So I think it's the court reporter to document the depot he had scheduled. He's trying to save money. So can I get your name for the record? Mr. Lauro, yes, Your Honor. So he is now going under oath, which is interesting because maybe he's not. Aren't attorneys like of the court, like not wards of the court, but representatives of the court? And everything they say has to be anyway. So I'm talking and skipping this. So he's basically saying the same thing. The state is requesting the court to compel Miss Adelson's testimony. Oh, this is different. Hold on, let's go back. Good afternoon, Your Honor. It's John Lauro. Lauro, and I'm counsel for Ms. Adelson. All right. And it's my understanding that the state is requesting the court to compel Ms. Adelson's testimony. Is that correct, Ms. Kappelman? Yes, Your Honor. And based upon that, Ms. Adelson, the testimony you provided, anything derived from this testimony cannot be used against you, but you will be required to answer all relevant questions. Do you understand that? The witness, yes, Your Honor. All right. Anything else you want to make of record, Mr. Lauro? No, Your Honor. Thank you. The court. All right. Anything else? Did the attorney just testify as behalf? Yeah, because it's go to the podium. Can I get your name for the record? Was called as a witness, having been first duly sworn, was examined and testified as follows. Okay, so Whitney, oh my God, Wendi is on the stand. And then they're going on about the court reporter. So I think, I mean, it feels like Judge Everett will just give this his blessing. It seems pretty cookie cutter to me, like it happened in the prior two trials. It doesn't seem like, well, the whole Rashi thing was interesting because he wasn't necessarily adversarial to her. It was almost like he was treating Wendi as his witness and no, you wouldn't do this and you wouldn't do that. I mean, Georgia was no holes barred. She ripped Wendi for the gods. Specifically when she was asking, like, does it make you mad that you were allowed to be living where your ex-husband's murderers lived and your brother and your mom knew and no one told you? And then Wendi tried to not answer the question. Well, I'm mad about a lot of things. And Georgia's like, well, I'm talking about this in particular. And then first she said, I'm mad that someone set out to kill my ex-husband or the father of my children, because those are the words Georgia used. I'm mad that someone set out to kill. Yes, but are you mad about, well, I'm mad about a lot of things, but are you mad about this in particular? So, but Rashi didn't really go after her. Do you know what I mean? So, yeah, that was like the whole thing with Rashi was weird. I have this question too. You guys let me know. Because Rashbaum represented Donna first. Did Donna sign a waiver for him to then represent Charlie? I mean, I guess she would have signed it if asked, but it just seems like whatever he knew from Donna as a unindicted co-conspirator was a conflict in support of Charlie. I mean, now that we know the reverse is true, right? So but I don't know if Judge Everett knew, like, does it have to be disclosed that he previously represented Donna in this matter? But she hadn't been charged yet. You know what I mean? Maybe the rules are different. I just think that whole thing is weird, and the way that Rashbaum cross-examined Wendi was weird. I have a feeling that Jackie is going to cross-examine Wendi, and it's not going to be nice. Do you know what I mean? I mean, not that she's going to like rip her to shreds, but I just feel like it'll be more adversarial, which it's meant to be, right? Like the law is adversarial, or the court proceedings. And so I feel like it'll be a little spicier. Rashi just softballed her. Or is it just me? What do you guys think? I should put clips in here, but I'm not going to. Because I'm trying to get these videos out while I have the energy. But what do you guys think? Is it, yeah, I just don't know why the defense even bothered to subpoena her. And I don't know what the transcripts, because I know they had put in a filing to depose Wendi, but I can't remember if it went through because there were a lot that got canceled. But if it did go through, I'd be interested to know if she just pled the fifth through the whole thing, because she certainly did that in Katie's case. And you're worried about wasting money on a court reporter. That is a waste of money. But you know, Donna's got those dollar bills to defend herself. So what's a few dollars? Hopefully, you know, it's settling in for Donna that this is happening and it's not looking good. But I don't know. I'm excited that the trial is starting now. I'm excited. I will be officially excited like once the first witness is sworn in, given what happened last time. But yeah, justice for Dan Markel, justice for all of the Markels. You know, it's been a long time coming and it's overdue, but I don't see how she gets out of it. You've got the consciousness of guilt for the trip that she booked to Vietnam via Dubai, non-extradition countries. You've got her script writing to the jail informant. You've got her on the wire when Charlie's like, "What's this about? Who's it involves?" And she was like, "Oh, just the two of us. And this TV is going to cost about $5." I don't have any doubt. I just hope in Georgia I trust that they lay it out exactly as they have in the other trials and that the jury sees it for what it is. We'll see. We'll see. I feel like there's going to be more stunts also from the Adelson tribe, or I don't know if I should call them a tribe, the Adelson defense team, because, you know, Judge Everett held the ruling on the motion for a new venue, right? They have to try and seat a jury. So I just wonder if there's going to be some shenanigans around that and they raise it again or what's happening. So yeah, we will see. And then Judge Everett, I guess, has to rule on Tuesday about this motion to suppress the Drina Bernhardt testimony. I don't think there's any other outstanding motions. I am going to do a video on the hearing that's happened last week. I am fixing the sound for Judge Everett because I want to react to that. Like, it's a little pitchy. And so, but that is coming. I'll have it up before we get to jury selection on Tuesday because I have thoughts and I want to know your thoughts on it as well. So I will catch you in the comments. Let me know what your thoughts are. I don't think any of us are surprised by this motion from Wendi, right? I guess I'm more surprised that the defense subpoenaed her. Let me know your thoughts on why you think they subpoenaed her and what they're trying to accomplish. And if you agree that Jackie will do the cross on Wendi and it won't be nice. Talk to you in the comments. Toodles.